I'm attorney Gloria Allred. I'm a partner in the law firm of Allred, Morocco, and Goldberg. I've been practicing law for 32 years. We are a civil rights law firm. We are devoted to winning rights, enforcing rights for our clients who have been discriminated against on account of their gender, their race, their condition of physical disability, their religion, their ethnic origin, their age, their sexual orientation, their condition of AIDS, and we do quite a bit of employment discrimination. That's mainly what we do for individuals who have been discriminated against by large corporations, small corporations, government, or anyone else who would deny and deprive them of their rights under the law. But we do victims' rights, and for 30 years we did family law as well, which is one of the reasons that this case, which involves family law as well as discrimination issues involving the right to marry for same-gender couples, the equal right to marry, was so important to us and was perfectly suited to our law firm. In the 32 years that we have been practicing law, we have won hundreds of millions of dollars for victims. We have previously won a case before the California Supreme Court in the family law area, and we were just very honored and excited to be able to take this case and win this case for Robin Tyler, Diane Olson, and our clients Reverend Troy Perry and his life partner Philip DeBleek. This is only our second case for the California Supreme Court, but I would say most lawyers never even have one case accepted before the California Supreme Court, let alone two cases and two victories. So we're very, very pleased and happy about that for our clients and for ourselves. I want to add that I used to be a teacher for many years in public schools. For about 6.5 years before I became an attorney, I was a teacher in Philadelphia, and then I was a teacher in Watts in Los Angeles 1 year after the Watts riots, or some people may call them the Watts Rebellion, in the 1960s. I asked to teach at Jordan High School, and then subsequently I also taught at Fremont High School. Well, originally I thought that I would go into law, and I had also been a full-time organizer for the Los Angeles Teachers Association, which subsequently became the United Teachers Los Angeles, which is the teachers union. And I thought I could help to improve conditions in schools as a lawyer. But then I decided to take a different turn with my career and entered law practice with two of my law school classmates whom I met, Nathan Goldberg, Michael Morocco, and I've been blessed to be able to work in the area of civil rights for these last more than 3 decades. Well, this is a case that we litigated for 4 years on behalf of our 4 clients. And when we argued it in the lower court, we were successful. Then it was reversed in the Court of Appeals, and then it went up to the California Supreme Court, which was where we all knew it would be ultimately decided. For a number of years, starting in 2004, I went with my clients to the Beverly Hills Courthouse, where they applied for a marriage license and were denied based on the fact that they were same-sex couples. And therefore we filed a lawsuit against Los Angeles County seeking to compel them to issue the licenses so that our clients could marry. And we argued that the failure to issue the license was a denial of equal protection under the law. Specifically, that 60 years ago, the court, in a California Supreme Court case, decided that the ban on interracial marriages was unconstitutional, a denial of equal protection, and they struck down the ban. That, we said, was a precedent for our case. Because in Perez versus Sharp, the court decided that an individual in California, an adult, has a right to marry the person of one's choice, has a fundamental right, that is a constitutional right, to marry the person of one's choice. So if that's the case for interracial couples, then the same concept that a person has the right to marry a person of one's choice should be, and in fact ultimately was applied, in the case of same-gender couples. That was the precedent. You know, I would sum up, in my opinion, their argument essentially as, well, this is the way it's always been. Tradition, as they would say in Fiddler on the Roof. Well, the status quo, the way it's always been, is not an argument as to why it should continue to be the way it is. If the way it has been is unconstitutional and a violation of civil rights. I mean, slavery was the way it was for many years in this country. Denying women the right to vote was the way it was for many years in this country. That doesn't mean that's the way it should continue to be.
Sure.
Essentially, their argument was that Proposition 22, which was a proposition, an initiative that was voted on and passed by the voters, which caused to be inserted into the family code, or the law of California, a provision that marriage is a union between a man and a woman. Their argument was that the voters passed it, and we have to respect the will of the voters, is the way I see their argument. The problem with that argument is that the ultimate expression of the will of the people is not an initiative or a proposition that the people vote on. The ultimate expression of the will of the people is the California Constitution, which is the blueprint. That is, that's what everything must be judged against. That is the framework for the law in California. And the California Constitution states clearly that each individual in California has a right to enjoy the equal protection of the law. So if a proposition, an initiative, is in violation of the right to enjoy equal protection under the law, it is for the court then, the Supreme Court, to strike down any law or proposition which is in opposite, that is, in contradiction to that California Constitution. That's, in fact, what was argued by those of us who wanted to strike down the ban on same-gender marriage. That's an argument that was successful.